Hey folks, good afternoon. My name is Greg McLawsen. I'm the Affidavit of Support lawyer. I represent plaintiffs in federal litigation to enforce the Affidavit of Support, and I serve as a consulting expert in family law cases when the Affidavit of Support has come up as an issue in a divorce. Today I wanted to talk about the timeline for resolution in these cases. It's really often when somebody comes to me to enforce an affidavit of support, one of the first questions they have is, how long is the case going to take? The answer is, I don't know. But let me tell you, generally speaking, what the best case scenario is, what the worst case scenario is, and then we'll kind of talk about where most cases tend to fall within those two extremes. First, best case scenario. So, as with any civil legal claim in the United States, most claims under the Affidavit of Support get resolved out of court through settlement. One thing I figured out through working with a lot of folks on these cases is that some people tend to think of settlement as representing a failure on the part of the plaintiff or the plaintiff's lawyer. So something I hear a lot from my clients is, I don't want to settle this claim. I want to fight it in court, and I want to enforce it in court. The purpose of going to court is never to go to court. The reason you go to court is if you have a legal claim and you don't have a better way to resolve it. The best possible way that you can resolve a legal claim is to do it voluntarily through settlement. So think about it as if you were a 7-year-old. You've got a playground dispute. You want the toy and Jack has taken the toy. What's the best case scenario? The best case scenario is you go to Jack and you say, hey, Jack, you got my toy. I'm entitled to the toy. And Jack says, I'm sorry. And Jack gives you the toy. That's the best case scenario. The worst case scenario is if you have to go running to your teacher and you say, Jack stole my toy and I'm entitled to the toy. And these are the reasons I'm entitled to the toy. It's mine. And the teacher has to step in and then maybe the principal's involved. But the best thing you can possibly do is walk away with your toy. And it's the same thing in affidavit of support cases. The best possible solution for the green card holder who has rights under the affidavit is to approach the other side. This is done preliminarily in a demand letter. And as the plaintiff's attorney, I say, here's what my client believes they are entitled to. Here are the terms on which they are willing to resolve their claim. And the sponsor says, well, that seems reasonable. That's the best case scenario. Within the span of a month or so, the plaintiff approaches the sponsor, explains the terms of a proposed resolution, and after some back and forth with the sponsor or their attorney, a resolution is reached. The green card holder is paid the support money that is owed, and both parties go on their way. Nobody has spent a ton of money on lawyers. Time hasn't been spent in court. Judicial resources haven't been spent in court. Everyone goes on their way. So some small percentage of cases under the affidavit of support actually do go that way, where there's a demand letter, very limited back and forth, nothing is seriously contested, and the claim is resolved. And that can get done within weeks, within less than a month. That's best case scenario. What does the worst case scenario look like? Well, if the best case scenario is two parties working cooperatively together, the worst case scenario is like that playground dispute where somebody wants to go screaming off to the teacher because their default mode is to fight, fight, fight. So worst case scenario is the sponsor says, forget it. There's no way I'm going to talk to you, the plaintiff's lawyer, about how this claim gets resolved. I think that I don't owe it. Penny, I'm mad and I'm going to go to court to fight. And I don't care, the sponsor says, ultimately, if you win or not, on the principle of the matter, I am going to fight this thing every step of the way. And it's like that old phrase, you can lead a horse to water, but you can't make it drink. As the plaintiff's lawyer, we can give a defendant sponsor every reasonable opportunity to settle a claim under the affidavit of support. But ultimately, if the sponsor isn't going to be reasonable, they do have the right to lawyer up and put us through the paces of proving our claim in federal court. And prove it up we will. Affidavit of support plaintiffs prevail in these cases. So there is no chance that the sponsor is going to win the case in terms of having the affidavit of support claim dismissed. But they can put us through our paces of proving that. So we file the complaint, the sponsor lawyers up, they file an answer which admits or denies the allegation in our complaint. Almost always what will happen is that the sponsor will assert what are called affirmative defenses. These are a little bit complicated, but it's a way of saying I agree to the allegations in the complaint for the sake of argument. But even if those are true, here are reasons why I, the sponsor, think I'm not liable. And sponsors will typically try to assert claims that apply in contract law. Well, there is really good case law here in the Ninth Circuit, out of the Western District of Washington, out of the Central District of California. There's a 11th Circuit case, there's a 7th Circuit case, and all of these cases say those types of defenses just don't apply in these cases. So usually it will be an attorney who's not very familiar with affidavit of support claims who will put these defenses in the answer. Well, then we have to go through the paces of asking them to withdraw those defenses. Often they won't. So then we'll file a motion with the court and say, Judge, here are all of these cases that explain why these defenses don't apply. And all of that takes time. So we'll go through that round of the case, then we'll go into discovery. That's the information exchange process. Usually the sponsor is going to want to explore what our client's income has been, et cetera, et cetera. So for a sponsor who wants to do that and wants to go through all of the steps of litigation, you're really looking at around a year, round figures. And you're looking at a lot of resources. People will often say, oh, we know that litigation is expensive. But for somebody who wants to defend a federal case of this nature, they're really looking at roughly $100,000 probably in their legal fees. And the affidavit of support statute includes something called a fee shifting provision, which means that the sponsor is responsible not just for their legal fees, but for the costs and legal fees of the plaintiff who ultimately prevails in the case. So that means that a sponsor might be paying $200,000 if they want to fight an ultimately losing affidavit of support claim. And after they lose in trial court, they have a right to go up and lose again on appeal to a circuit court, and they can do that. If you want to see a couple examples of these worst case scenarios, look at the Erler litigation out of California, or the Dorsinio litigation. That was a case that I represented the plaintiff in. And on both of those cases, there was a fight, and lose at the trial court level, and then fight, and lose again on the appeal level. Then it goes back to the trial court. Nothing is won. Nothing is won by going that route. So the plaintiff doesn't end up any better. That's the affidavit of support beneficiary. She ultimately just walks away with what she was entitled to begin with, which is relatively easy to calculate under the affidavit. You can see other videos, but that's tied to the income level of the beneficiary. And the sponsor definitely has not won anything by spending all of these resources litigating the claim in federal court, litigating it again on appeal, and coming back just to lose again in the trial court. That sponsor, again, is not ever going to get a court win to have that affidavit of support claim thrown out. The very best thing that a sponsor might be able to achieve in court is to reduce the damages that the beneficiary is entitled to. So in some federal districts, there might be some wiggle room for push and pull about how the beneficiary's damages are calculated. But it is never going to make financial sense for the sponsor to spend $200,000 to litigate a case fighting over a few $1,000 as to what damages the plaintiff is entitled to. So smart defense attorneys of the country will focus their energies in a focused way early in these cases on trying to figure out what it's going to take for the parties to come to the table and pencil out a resolution that both parties can deal with. And so we've talked about the best case scenario and the worst case scenario. Where most of these cases fall is that they get resolved somewhere within the first, I would say, 3 months of after they are initiated. So oftentimes the sponsor will try to ignore the initial demand letter. And I get it. I mean, we've all had that unexpected bill that comes in the mail, and most of us don't have the initial inclination of just sending off a check, right? The first response some people have is, maybe there's a way I don't have to pay this. So that's an understandable response. The defense will often ignore that initial letter. Ultimately, if they're going to ignore it, the plaintiff doesn't really have any other option except to file the federal claim. So the complaint gets filed. At this point, we're a month or so into the process. Often that's when the sponsor lawyers up. And, then you get into this dance where the answer is filed by the sponsor. Maybe those affirmative defenses that I mentioned get raised. And then there's some push and pull between the parties in terms of trying to figure out what's actually in dispute in these cases. If the sponsor has a good defense attorney, they will wrap their heads pretty quickly around the idea that the case law is strongly in favor of the affidavit of support plaintiff. And we are not going to have a battle about whether the sponsor has liability. That ship has sailed, and the sponsor is going to be on the hook for paying something to the sponsored immigrant. If there's a battle at all, it's going to be a little bit of push and pull about what exactly a fair settlement looks like. We have other videos on this, but usually in settlement, there are two components. One is what damages have occurred so far, so how much money is owed up to a certain date, and then also thinking about the future value of claims under the affidavit, because oftentimes everybody just wants to have a global settlement that represents the sponsor's total liability, and everybody can just walk away and move on with their lives. And so if we're thinking about what's the future value of the beneficiary's claim under the affidavit, that is a type of process where both parties have their own view and there's some give and take in terms of what the case valuation is. But that's where the energy on these cases should be spent. It should be spent at the bargaining table with both parties doing their good faith best to sit down and think about what a resolution is that both parties can deal with. So again, best case scenario is really quick, within a month or so, settlement gets penciled out. Worst case scenario is thermonuclear war in the litigation context that takes easily upwards of a year. But the reality in terms of having done many of these cases is that most of them are in that several month period where, yes, there's a little bit of litigation, but before things get really, really grisly in the litigation process, people decide to be adults and sit down and work things out. Hope this has been helpful. If you have general questions about the affidavit of support and the litigation process, feel free to drop them in the comments. I'll be happy to answer them there. If you have case-specific questions, we offer free case assessments and consultations to affidavit of support claimants and also to family law attorneys who have questions about enforcement. go to soundimmigration.com and you can get a free consultation there. Hope this is helpful. Everyone have a good day.